I'm Mark Jefferson, and I've been practicing family law in Texas for 18 years, a journey that has exposed me to the rawest edges of human desperation and resilience. Some cases etch themselves into your memory, not just for their legal complexities, but for the sheer human drama they unveil. This one began, as many often do, with a knock on my office door, but the story behind it painted a picture so stark, so heart-wrenching, that it gripped me instantly. The Texas Department of Family and Protective Services, what most folks simply call CPS, had removed Sarah Miller's two young children from her home. Emily, 7, and Jacob, 5, were now in foster care. Snatched from their mother's arms after an anonymous tip led caseworkers to a house described in the initial report as uninhabitable due to extreme hoarding conditions. My stomach dropped as I read the first few lines of the CPS report Sarah clutched, her hands trembling so violently I feared the paper might tear. It detailed a scene of unimaginable squalor, pathways carved through mountains of trash and possessions, expired food creating a stench that permeated every corner, rat droppings visible on almost every surface, and a bathroom that hadn't seen a clean cloth in years. One detail in particular made my blood run cold. The only functioning kitchen appliance was a microwave, precariously balanced on a stack of newspapers amidst piles of dirty dishes and rotting organic matter. The children, according to the report, had been sleeping on a mattress barely visible beneath layers of clothes and garbage. This wasn't just neglect. This was an environmental disaster for two innocent kids. Sarah sat across from me, her eyes red-rimmed and swollen, her hair disheveled, a faint, stale odor clinging to her clothes despite her obvious attempt to appear presentable. She looked utterly defeated, a ghost of a woman. She whispered that if I couldn't help her, she had nothing left to live for. The stakes couldn't have been higher. The state was moving towards permanent termination of her parental rights, meaning she could lose Emily and Jacob forever. This wasn't about money. It was about the fundamental right to be a mother. Here's what you need to understand about the legal framework governing child protection cases in Texas. When CPS gets involved, they operate under the Texas Family Code, specifically sections related to child endangerment, removal, and ultimately termination of parental rights. Under Texas Family Code, paragraph 262. 1-1, CPS can remove a child from a parent's home if there's an immediate danger to the child's physical health or safety. That's a low bar, and in a hoarding case, it's easily met. Once removed, the clock starts ticking. The focus shifts to the best interest of the child, a legal standard that guides every decision a judge makes in these cases. It's a broad concept, encompassing the child's physical and emotional needs, stability, safety, and relationship with their parents. For the state to permanently terminate parental rights, they must prove specific grounds under Texas Family Code, paragraph 161. 001, things like abuse, neglect, or failure to provide a safe environment, and also prove that termination is in the child's best interest. This is a very high bar, intentionally so, because the law recognizes the profound importance of the parent-child bond. My job, in Sarah's case, was to prove that while conditions were undeniably horrific, they stemmed from a treatable mental illness, not malicious intent, and that with the right intervention, Sarah could provide that safe home, making reunification, not termination, truly in Emily and Jacob's best interest. It was an educational process for Sarah, who, like many, thought CPS was simply out to punish her. I explained that they were mandated to protect children, and my role was to work within that mandate to protect her family. My client, Sarah Miller, was 34 years old. She had been an administrative assistant before the hoarding consumed her life and her job. Now, she was unemployed, adrift, and crippled by her condition. Her personality, before the weight of her illness, had been described by her mother as gentle, artistic, and kind. But the person who sat in my office that day was a shadow, overwhelmed, deeply ashamed, and utterly terrified. She loved her children with a fierce, almost desperate intensity, but that love had been tragically insufficient to overcome the crushing grip of her hoarding disorder. It was her estranged younger sister, Lisa, who had finally called CPS. Lisa had tried to help Sarah for years, had even attempted interventions, but Sarah always pushed her away. Finally, seeing Emily and Jacob's deteriorating health and the unbearable living conditions during a rare, unannounced visit, Lisa made the call. CPS caseworkers arrived at Sarah's home on March 12th, a modest brick house in a quiet Dallas neighborhood, and the scene they found confirmed Lisa's fears. The children were immediately removed. The initial hearing was set for April the 10th. Sarah, completely broke, had reached out to her elderly mother, Martha, who, despite her meager savings, scraped together a small retainer for me. Martha, eyes brimming with tears, told me Sarah had been a wonderful mother, until the stuff started taking over a few years ago. Sarah initially tried to minimize the severity of the hoarding, her shame preventing her from full disclosure. She just kept repeating, "I love them, Mr. Jefferson. I couldn't stop." It was in that moment, seeing the genuine anguish in her eyes, the raw, visceral pain of a mother separated from her children, that I knew I had to take the case. It wouldn't be easy. It would be a brutal, uphill battle against mountains of evidence and an unforgiving system. But I saw a flicker of hope in her, a desperate plea for a chance at redemption, and I believed she deserved that chance if she was willing to truly fight for it. My first task was to get a complete picture, as painful as it might be. I reviewed the CPS report thoroughly, poring over the hundreds of devastating photos and the shaky caseworker video footage that documented the chaos within Sarah's home. The images spoke volumes. Narrow, winding paths barely navigable, leading from the front door to a living room swallowed by stacks of newspapers, broken furniture, and bags of what looked like old clothes and food wrappers. The children's beds were literally piles of objects with small indentations. The bathroom was unspeakable. The sheer scale of it was mind-boggling. With Sarah's permission and a CPS escort, I visited the house myself. The moment I stepped inside, the oppressive stench hit me, a nauseating mix of mildew, stale food, animal waste, and something indefinable, synthetic and old. It was hard to breathe. I walked carefully through the labyrinthine paths, feeling the instability of the piles around me. My stomach churned. This was far worse than the pictures could convey. My immediate strategic pivot was clear. This wasn't a case where I could deny the conditions. The evidence was irrefutable. Instead, I had to frame it as a mental health crisis that was treatable. I knew I needed an expert. I hired Dr. Evelyn Reed, a clinical psychologist renowned for her work with hoarding disorder and attachment theory. She had an impeccable reputation in Dallas and had served as an expert witness in similar cases. My goal was twofold: get a comprehensive diagnosis and, more importantly, a detailed prognosis and treatment plan for Sarah. Dr. Reed began intensive evaluations with Sarah immediately. Simultaneously, I started reaching out to resources, professional organizers specializing in hoarding, support groups, and even contractors for potential remediation. This wasn't just about winning in court. It was about truly helping Sarah create a safe home. The investigation was fraught with tension. Sarah initially struggled to fully engage with therapy, her shame and the sheer enormity of the task overwhelming her. There were days she'd cancel appointments, days she'd call me in tears, wanting to give up. Each phone call felt like a dead end. CPS, through their Assistant Attorney General, Arthur Jenkins, was unyielding. Jenkins was a formidable opponent, known for his thoroughness and his successful track record in terminating parental rights in severe neglect cases. His reputation preceded him. He rarely lost a case where the initial conditions were as egregious as Sarah's. He sent me discovery requests seeking every bit of Sarah's mental health history, her financial records, anything that could paint a picture of long-term instability. He knew her past struggles, including a previous failed attempt at therapy a few years prior for anxiety, and he was ready to weaponize it. But I wasn't deterred. I kept pushing Sarah, reminding her of Emily and Jacob. I also spent hours researching hoarding disorder, understanding its insidious nature, and how it often co-occurred with other mental health issues like anxiety and depression. I compiled timelines, noting every small effort Sarah had made in the past, however short-lived, to show a history of struggle, not indifference. Two key pieces of evidence emerged from this phase that would prove crucial. First, Dr. Reed's initial comprehensive psychological assessment, which, while confirming severe hoarding disorder, also detailed Sarah's underlying love for her children, her capacity for change, and her expressed remorse, contingent upon intensive and consistent therapeutic intervention. Second, a meticulously crafted, multi-phase treatment and remediation plan developed by Dr. Reed, laying out a concrete, actionable roadmap for Sarah's recovery and the restoration of her home. This wasn't just a wish, it was a blueprint. The real breakthrough moment didn't come from finding a hidden document or catching someone in a lie, but from the painstaking, emotionally draining work of getting Sarah to truly confront her illness and commit to the path Dr. Reed had laid out. I sat in on one of Sarah's therapy sessions with her explicit consent, where Dr. Reed was guiding her through an exercise involving visualizing her children in her current home versus a clean, safe one. Sarah had been resistant for weeks, minimizing, deflecting. But that day, something broke. She started describing the small, terrified face of Emily trying to navigate a path through the debris, Jacob coughing from the dust and mold. She saw it, truly saw the danger, the terror in their eyes. She started to sob, a deep, guttural sound of anguish and regret that shook the room. My heart raced, not from excitement over a legal win, but from the profound relief of witnessing a person finally breaking through the walls of their denial. "I want them back, Mr. Jefferson. I'll do anything," she choked out, her voice raw. This was the turning point. This wasn't just words, it was a soul-deep commitment. The discovery was Sarah's absolute, unwavering resolve, coupled with Dr. Reed's comprehensive, detailed, and evidence-based reunification plan. This plan wasn't just vague promises. It outlined weekly individual therapy for Sarah, family therapy with Emily and Jacob once supervised visits ramped up, specialized in-home organizational coaching by a team trained in hoarding intervention, and a timeline for professional home remediation, all under Dr. Reed's clinical oversight. It was legally significant because it transformed Sarah from a hopeless case in the eyes of CPS into a patient, actively engaged in a rigorous recovery process, demonstrating a genuine, measurable path towards providing a safe and nurturing home. When I presented the full plan to Sarah, explaining how it would be her lifeline, she clutched the document to her chest, tears streaming. But this time, they were tears of determination, not just despair. She felt for the first time a glimmer of hope that she could reclaim her children. The day of the hearing arrived at the Dallas County Juvenile Court, and the air in Judge Eleanor Vance's courtroom was thick with tension. Judge Vance, a woman known for her keen intellect and no-nonsense approach, presided with an air of stern but fair authority. Arthur Jenkins, the Assistant Attorney General, was already there, looking impeccably sharp and confident, his piles of documents ready. My strategy hinged on demonstrating Sarah's transformation and the viability of the expert-backed remediation plan. My key witness was Dr. Evelyn Reed. She took the stand, calm and authoritative, explaining hoarding disorder not as a character flaw, but as a complex mental illness often rooted in trauma and anxiety. She detailed Sarah's specific diagnosis and the scientific basis for the aggressive treatment plan. "In your professional opinion, Dr. Reed," I asked, "is Ms. Miller, with the comprehensive treatment plan currently underway, capable of providing a safe and nurturing environment for her children?" Dr. Reed looked directly at the judge. "Absolutely, Mr. Jefferson. While the journey is ongoing, Ms. Miller has demonstrated remarkable commitment and progress in therapy. Her capacity to understand her illness and actively participate in her recovery is significant. With proper supervision and adherence to the plan, I am confident she can provide a safe and emotionally supportive home for Emily and Jacob." Jenkins launched into his cross-examination, attempting to discredit Dr. Reed's optimism. "Dr. Reed," he began, his voice laced with skepticism, "are you suggesting that a home previously deemed uninhabitable, filled with biohazards and rodent infestations, can be transformed into a suitable environment for children in just a few short months? And are you suggesting Ms. Miller, who failed to maintain her home for years, can suddenly sustain this change?" Dr. Reed remained composed. "Mr. Jenkins, the plan includes professional remediation and ongoing organizational coaching, not solely Ms. Miller's efforts. Furthermore, Ms. Miller's previous struggles were due to an untreated illness. Her current progress, supported by intensive therapy, indicates a profound shift. We are not expecting instantaneous miracles, but a structured, monitored, and supported path to reunification, which is vastly different from her past attempts. I then called the CPS caseworker, Ms. Rodriguez, to the stand. While she had initially been steadfast in her recommendation for termination, I gently walked her through the evidence of Sarah's progress. I presented updated photos of the house, showing significant portions now cleared, organized, and professionally cleaned, along with detailed reports from the in-home organizers and therapists. I emphasized reports from the supervised visitation supervisor, which detailed positive, loving interactions between Sarah and her children, and Emily and Jacob's clear desire to be with their mother. Ms. Rodriguez, I asked, given the documented progress in Ms. Miller's home and her adherence to the therapeutic plan, and the clear bond observed during supervised visits, do you believe permanent termination of parental rights is the only viable path to ensure Emily and Jacob's best interest? Ms. Rodriguez hesitated, looking at the photos, then at Sarah, then back at me. Her face, which had been impassive for months, showed a flicker of uncertainty. "Mr. Jefferson," she said slowly, "the initial conditions were severe, no doubt, but Ms. Miller has made significant efforts. Our primary goal is always reunification when safe and appropriate." Jenkins looked frustrated, his jaw clenched as his own caseworker seemed to be softening. My closing argument was direct, appealing to Judge Vance's wisdom. I acknowledged the terrible neglect but stressed that the best interest of the child includes the preservation of the family unit when a parent demonstrates a genuine, sustained capacity and willingness to change. I reminded the court that Sarah's children were not abused but neglected due to a treatable illness, and that she was now actively engaged in that treatment. The courtroom went silent as I finished, the weight of Emily and Jacob's future hanging heavy in the air. Judge Vance retired for what felt like an eternity, though it was likely less than an hour. When she returned, the silence in the courtroom was absolute. Her gaze swept over us, finally settling on Sarah. "Ms. Miller," she began, her voice measured, "the conditions detailed in the initial CPS report were abhorrent and placed your children in grave danger. No court could or would ignore that." Sarah flinched, her eyes cast down. "However," the judge continued, "this court has also heard compelling testimony regarding your diagnosis, your commitment to treatment, and the significant documented progress you have made in remediating your home and addressing your illness. The expert testimony of Dr. Reed, and indeed the caseworker's own observations, suggest a viable path to reunification. Therefore, I am ruling against immediate termination of parental rights." A collective gasp rippled through the courtroom. Sarah gasped, a small, choked sound. "Instead," Judge Vance announced, "Emily and Jacob will remain in foster care for now, but Ms. Miller will be ordered to continue with the comprehensive treatment plan outlined by Dr. Reed, including intensive therapy, ongoing home remediation, and increased supervised visits. The CPS case will remain open with quarterly reviews, and the focus will shift to reunification, contingent on Ms. Miller meeting all specified milestones within a 6-month period. Failure to comply will result in a reconsideration of termination. It wasn't full custody yet, but it was a lifeline. Sarah broke down, sobbing uncontrollably, but this time they were tears of overwhelming relief and hope. Jenkins' face was unreadable, but I could sense his quiet defeat. 6 months later, after meeting every single condition, passing every home inspection, completing countless therapy sessions, and demonstrating consistent progress, Emily and Jacob were finally returned to Sarah's now clean, safe, and organized home. It was a conditional reunification with continued CPS oversight, but they were home. Here's what I learned from this case, something that continues to shape my practice. Parental love, even when buried under layers of mental illness, shame, and despair, is an incredibly powerful force. It reminded me that sometimes the opponent isn't malice or deliberate cruelty, but a treatable condition that, left unchecked, can wreak havoc. The legal system, while necessarily focused on protection, also has a capacity for rehabilitation if the client is truly committed to change. The best interest of the child is not always a static concept. It can evolve as a parent evolves. It doesn't always mean severing ties permanently, especially if a genuine, supervised path to safety can be established. For anyone facing similar challenges, the warning signs are critical: extreme isolation, overwhelming clutter that impacts daily living, and an inability to discard items that affects hygiene and safety. If you see these in yourself or a loved one, seek help immediately. Don't wait for CPS to knock on the door. If you are facing CPS involvement, the absolute worst thing you can do is deny the problem or resist help. Immediately seek legal counsel, engage with the services CPS offers, and demonstrate proactive efforts to address their concerns. Show the court you are willing to fight for your children by fighting for yourself. My professional insight from this, and countless other cases, is that human beings are incredibly resilient. When faced with the ultimate loss, their children, people can find a profound strength they never knew they possessed. Sarah Miller did, and in doing so, she taught me a powerful lesson about hope and the human spirit. Sarah has not only maintained her home since Emily and Jacob returned, but she's also continued her therapy and even joined a support group for parents recovering from hoarding disorder. Emily and Jacob are thriving, back in school, catching up on their studies, and most importantly, happy to be home with their mother. They still have occasional family therapy sessions to process the trauma, but their laughter now echoes in a house that once held only silence and despair. This is why I do what I do: to fight for those who feel they have no fight left, to give second chances when they are earned, and ultimately to protect children by also helping their parents become the best versions of themselves. Drop your questions in the comments below about this case or any other legal matters. I've got plenty more stories to tell, from battles over fortunes to the fight for freedom. So, stick around.